We now move on. Segment 2 tonight on CCC. A whistleblowing report comes from the Department of Defense through this host, and it has materialized just this week that civil rights attorneys who protect federal employees no longer have the protections of the rules of professional conduct, according to an apparent interpretation by a Maxwell Selz. Maxwell Selz is the Assistant General Counsel of the U.S. Department of Defense and the Department of Defense schools, and Maxwell Selz, in a case that I'm in, has taken the position, to quote Maxwell Selz, government lawyers are exempt from trust fund requirements since they never personally hold funds. Understood. And then he said, are you able to point to a case where a federal agency has withheld payments to an Equal Employment Opportunity Commission or Merit Systems Protection Board litigant based on an attorney's charging lien? I served an attorney's charging lien this week. The existence of a fee dispute is not a question between attorney and client, but what is a question, according to Maxwell Selz, is whether government attorneys have to follow professional ethics rules that require them to hold funds that are in dispute. It's the client property rule. Mr. Selz is admitted in Nebraska, and I provided some Nebraska law eventually that indicates the obligations of any attorney out of Nebraska and other jurisdictions. I taught professional ethics for 6 years, so I'm a professional legal ethicist, and the principle and policy and rules are to preserve the disputed funds until such a fee dispute is resolved. If you didn't do that, then attorneys wouldn't bother to represent people on any form of contingency fee, because a litigant could simply take all of the attorney's earned fees and disappear. So a duty to the system exists among all lawyers. So the breaking news on this is that the attorney's charging lien, according to this government lawyer, Maxwell Selz, may not have to be given any effect at all. The federal government attorneys don't seem to address this. I have written over him to Kevin Greenfield and Liz Banger, as well as General Counsel of the U.S. Department of Defense, the big General Counsel at the Pentagon, Caroline Krass. So Caroline Krass has not answered either the charging lien served on her agency or this interpretation of Maxwell Selz that is leading him not to affirmatively answer me after now 17 days that the attorneys in the government are under an obligation to hold disputed property funds because of the valid attorney's charging lien. This will have a chilling effect on your ability, viewers, to get legal representation, because if attorneys on the opposing side can simply take away disputed earned fees, then there's no reason to continue in any contingency matter. An attorney who's working for these victims has no way of trusting the system to follow that law. The District of Columbia law supplies an attorney's lien in common law, has done so for more than 100 years. So it's very interesting that an attorney's charging lien is being invalidated, evidently, as far as I'm concerned, to the extent that Kevin Greenfield, Liz Banger, Assistant General Counsel of the Department of Defense, Caroline Krass, the General Counsel, have remained silent on my inquiries. And this is something I'm doing. I'm the co-convener of the District of Columbia chapter of the National Conference of Black Lawyers. I co-lead that organization, and we are looking at this because it's really an attempt to prevent aggrieved African American civil servants from having powerful representation that relies on these policies protecting the recoveries for the proper distribution of those, both to client and attorney. So we're going to be watching this, and I'm inviting Mr. Selz and General Counsel Krass on this air right now to face the African American civil servants of Prince George's County, of the District of Columbia, and of Northern Virginia, and explain your position so that we can understand. If it's the case that the federal government does not follow charging liens on these settlements where there's no dispute of the validity of the lien and the existence, at least the validity of the existence of the lien and a validity of a dispute, existing, then come and say so that everybody can stop serving civil servants who at least are working on contingent fee or partial contingent fee bases. Again, this invitation is to you, and we can come back next week, Caroline Krass and Maxwell Selz, admitted in Nebraska, where I've supplied copious guidance from that Office of Disciplinary Counsel in Nebraska at the Supreme Court there, with whom I spoke about this problem. The phone lines are open. Anyone who's concerned about the ability of litigants to be protected by having counsel who can rely on being able to recover the earned fees, call right in. This is WBGR, you're live on the air, and the topic is the federal government's abrogation of the attorney's right to have a disputed property / fund held until the dispute is over. Yes, you're live.
Attorney Jones, I am just watching with my family, and I'm just flabbergasted by these heinous, egregious actions. And I'm just wondering, do we have any civil liberties or rights anymore? And who in the world is behind all of this?
That's a very good question, caller, and I thank you. Do we have any civil liberties and civil rights anymore? And who's behind this? Well, I'm going to leave that question open. I thought we did, but Maxwell Selz's email trail, which included questioning whether, before there was even a fee dispute, whether my fee, which is based on the government Laffey matrix, which is a bare minimum attorney fee recognized in the civil service, whether I am entitled to that rate. You can Google Amos Jones lawyer and find out the kind of lawyer that I am and the way in which I serve people and the difference that we're making across this country, and understand that for me to charge the minimum standard in arrears is exceedingly unusual. And that's because I believe that good, middle-class, hardworking people deserve high-quality representation. It appears to me that we don't have these civil rights. The fee-shifting statutes that are in the civil rights laws all the way back to the Civil Rights Act of 1866, in the Reconstruction era, to have African Americans have the ability to go into court and to know that they might have rights because the Constitution said black slaves, and we were all slaves pretty much, but a few of us, that we were nothing but 3/5. It seems to me like maybe there's a 3/5 law working at the Department of Defense in the Legal Counsel Office. I asked Mr. Selz, and please come on, I'm just asking questions. You're a government worker and a civil servant, so you're a lawyer, Mr. Selz. You're a vet military guy. You have served, I guess, to help our country. So come on here and explain to people like the caller why you think the fee-shifting policies and statutory text and the ethics rules exempt this large group of attorneys / agency with regard to disputed property. Tell me what you think the effect of that is, since I think you're misreading the statute, the rules of ethics, and misinterpreting the policy, and that I'm forever trying to explain to judges and other people how that happens, and we have to spend 5 years in court usually to go to a Supreme Court or something to get a unanimous reversal of all these bad decisions. But the Department of Defense's integrity is in your hands at this point, Mr. Selz, and I hope you come on here, and if you don't, maybe your bosses will. Caroline Krass, the General Counsel, she went to Yale Law School, and I'm counting on her to set the record straight.